I'd seen this back in, I guess, March when the Supreme Court of Illinois overturned this Eavesdropping Act. But the state legislature decided just to slightly rewrite the law, and they passed it again. And they passed it overwhelmingly. The vote in the House was 106-7, and the vote in the Senate was 46-4 with one abstention. So they bipartisanly passed this law, basically saying don't record the police. Last week, the Illinois General Assembly overwhelmingly approved a new eavesdropping law that purports to meet the court's constitutional concerns. Whether it actually does is a matter of dispute. So Jacob Hubert, senior attorney at the Liberty Justice Center, argues the new version is nearly as bad as the old one, since a citizen could rarely be sure whether recording any given conversation without permission is legal. The bill says consent is required whenever one or more parties intended the communication to be private nature under circumstances reasonably justifying that expectation. It adds that a reasonable expectation shall include any expectation recognized by law, including but not limited to an expectation derived from a privilege, immunity, or right established by common law, Supreme Court rule, or the Illinois or United States Constitution. Clear? Got that? Because it's hard to predict how the courts will parse those words, those issues, Hubert says people recording conversations will often be unsure whether they're committing a felony. That's the thing. It's a felony. So you lose your right to guns. You can't vote. Good luck getting a job just for recording a conversation. The Illinois Supreme Court, for example, indicated that police performing their duties in public places do not have a reasonable expectation of privacy. But what about a cop who enters someone's backyard or serves a warrant in a private office or residence? Is recording what he says in those settings legal or not? What about telephone conversations with public officials about public matters? Does a citizen risk prosecution and imprisonment by recording those interactions without consent? In addition to this sort of uncertainty, Hubert notes, the eavesdropping bill retains another odious aspect of the old law. It punishes unauthorized recording of public officials, specifically police officers, prosecutors, and judges, the big three of corruption, more severely than unauthorized recordings of ordinary citizens. The former would be a Class 3 felony, punishable by 2 to 4 years in prison, while the latter would be a Class 4 felony, punishable by 1 to 3 years in prison. If anything, that is opposite to the distinction the law should draw, since public officials, given the power they wield, should be subject to greater scrutiny than private citizens. There's only one apparent reason for imposing a higher penalty on people who record police in particular: to make people especially afraid to record police. Hubert writes, this is not a legitimate purpose. So obviously this is going to go back to the courts. Someone's going to challenge this law, and the Supreme Court unanimously overturned the old law. So let's see what they do about this one. And I'm guessing if they overturn it again, because it passed basically unanimously in the legislature, they're just going to rewrite it again and try it again. So step by step, piece by piece, they're taking our rights away. And very soon, just about everything is going to be illegal. Get everybody a record, get everybody in the system.